What is the K-1 fiancé visa immigration process? That's what we're talking about in today's episode of Sumner School Family Immigration Basics. My name is Emily Sumner with Sumner Immigration Law. Let's get into it. So as always, this video is for informational and educational purposes only. It is not legal advice and it is not a do-it-yourself checklist to do it yourself. So let's talk about high-level overview. There are three major parts to the K-1 fiancé visa process that also includes the green card. The first stage is the I-129F. So to begin with, it has to be a U.S. citizen petitioner. If the person in the United States sponsoring the K-1 or filing for the K-1 is not a U.S. citizen, unfortunately, they're not eligible. So in other words, green card holders are not eligible to file the petition to sponsor their partner to come over on the K-1 fiancé visa. It has to be a U.S. citizen. So the U.S. citizen files the form I-129F with USCIS. We also include documentation of the relationship to show that it's a true relationship and not just for benefits of the green card. Once that petition is approved, and I would love to talk about processing times, I'll talk about it high level at the end, but they really vary. And it's hard to give precise processing times that don't just change, that then don't change over time. So once the I-129F petition is approved, it is forwarded to the consulate, the relevant consulate, wherever the foreign national partner lives, in whatever country they live. So the foreign national partner then would receive notification, and we would, if we're the attorney of record for the case, if we're helping you walk through the case, we would receive notification from the consulate once they receive that petition. Every consulate, every post has a slightly different process for processing all different types of applications, but especially K-1. Slightly different processes, and it changes over time. Generally speaking, the consulate will contact the applicant, the person who's applying for the K-1 visa, and will let them know that they have the petition and what the next steps are to schedule the interview, what documents are required, how to submit those documents. Sometimes they're submitted ahead of time. Sometimes you bring them to the interview. So the foreign national partner would then schedule the K-1 interview. You do have to have a medical exam done, and there are certain documents that the foreign national partner will need to bring to the interview, or like I said, submit ahead of time. So you want to make sure that you have all of those documents lined up, that everything is proper, and to reduce the chance of rejection of the visa and or delay. So once the foreign national partner is able to schedule that interview, they attend the interview at the U.S. consulate. The officer will go over the application. They will ask questions of the person who's applying for the K-1 visa to make sure that they're eligible for the visa, and to make sure that, to the best of their ability, that it is a true relationship and not just for benefits of a green card, which can be fraud or misrepresentation. Assuming that interview goes well, the foreign national partner should receive the visa back in their passport. So you leave the passport with the officer for them to physically place the visa in the passport. You should receive that back usually within a few weeks. Sometimes there are processing delays depending on the situation, but usually within a few weeks, if not sooner, you receive that visa back. It is a one-time use visa. So you use that K-1 visa to enter the United States one time. When you enter the United States on the K-1 visa, you have 90 days to get married to the U.S. citizen sponsor who submitted the I-129F petition. So that's important, that you're marrying the same person that you began this process with. So you have 90 days to get married. That marriage just has to be legally recognized. It does not have to be a whole big celebration. You can do that later. You can do that never, whatever works for you. But you do have to be legally married within 90 days. Then the foreign national, now spouse, will submit the I-485, which is the application for permanent residence, or the application for the green card. When you submit the I-485, you can also apply for a travel document and a work permit as well. You also have to submit other documentation. We include updated documentation of the relationship, and you have to include the affidavit of support. And again, we'll have additional videos about the affidavit of support requirements down the road. So you submit that documentation to USCIS. There are potentially other forms involved as well. Like I said, this is not legal advice or telling you how to do it yourself. So make sure that you follow all the instructions if you are doing this on your own. But you submit that to USCIS. You should receive receipt notices within about 2 to 4 weeks. The foreign national spouse might be called into the local USCIS office for fingerprinting. The foreign national spouse then should receive the work permit in the mail. Typically, that's around 6 to 9 months after we file the I-485, but that's, like I said, subject to change. And then you probably will be called in for a joint interview with USCIS. Sometimes those are waived. With the current administration, we're seeing that interviews are happening pretty much for all marriage-based filings. So you'll be called in for a joint interview at the local office with USCIS. They will review the application with you. They will make sure that the foreign national spouse is eligible for the green card, and they will ask questions about your relationship, again, to make sure it's a true relationship and not just for benefits of the green card. After the interview, typically our clients receive the green card in the mail within a few weeks after the interview, unless there's a request for evidence. If something is missing or USCIS has a question about something, they will issue either request for evidence, which we call an RFE, or a notice of intent to deny. So if you receive those, you definitely want to follow those instructions and make sure that you're getting the information. I would recommend that you consult with an immigration attorney if you have filed on your own at that point. But otherwise, you receive the green card in the mail. You most likely will have been married for less than 2 years at the time you receive the green card. If that's the case, you will receive conditional residence. That means the green card is valid for 2 years, and you have to file a petition to remove the conditions within the 90-day window before that green card expires. So that's a separate filing with USCIS, separate filing fee. So that is the very quick, high-level overview of the K-1 fiancé visa process. So let's talk about a couple of other things. First, let's talk about timelines. Everyone wants to know how long it will take, and that's absolutely a reasonable question. The answer is it depends. It really varies. So the I-129F, that first portion of the filing, in recent times has taken over a year to be processed, but in more recent times, it's taken closer to 3 to 6 months to be processed. So it really varies. There are a number of factors, including which USCIS office it actually goes to, which you really don't have control over necessarily. So that can really vary. It can take from a few months to a year or more. Then at the consular level, the time that it takes to have the interview scheduled also varies, depends on how busy the consulate is, how efficient they are. Usually it's a matter of a couple of months at that particular level, could be longer, could be closer to 6 months, but again, it varies. How quickly you get the visa back after the interview, again, varies. I know this is all I'm saying is it varies, it depends, but it's true. You really have to plan for a lot of different contingencies. So to get the visa back, if everything goes well, it's usually a couple of weeks or less sometimes. But like I said, there can be delays completely outside of your control, not caused by anything that you did, or can be caused by a particular problem with your application, but that can delay the issuance of the visa for weeks or potentially months. And then once you're here in the United States and you submit the I-485, we find that those processing times are longer than other types of I-485 filings for whatever reason. And there are exceptions, of course, but you're probably looking at least a year. Again, that is subject to change. We've had cases that are processed faster than that and longer than that, and it's always subject to change. But the biggest thing that I walk through with clients when I'm looking at timelines, especially for the K-1 visa, is most of the time their primary concern is how long is it going to be from the time we file the petition to the time that the foreign national partner is able to enter the United States. They, of course, want to get the green card, and they're concerned about that timeline as well. But typically the timeline we're really focused on, at least initially, is the estimated time from the time you start the process to the time that you're able to get to the United States. So that's what I would focus on if I were starting this process. A couple of other tips, whether you are working with an immigration attorney or not, and of course I recommend that, but people do file on their own, sometimes successfully, sometimes not. And the same is true with working with immigration lawyers. I would absolutely make sure that you are qualified for the process. There are both to file a petition, the I-129F petition, there's certain requirements for that, including but not limited to, certainly not limited to being a US citizen. and make sure that you meet the requirements for being able to immigrate to the United States, or make sure you're able to come on the K-1 visa and then eligible for the green card. If you have a complex immigration history, or really anything in your immigration history that you're not sure about, you're concerned it might cause a problem, consult with an immigration attorney to make sure that that will not be an issue. Likewise, if there are criminal charges, even if they have been expunged or dismissed for either partner, it's really important to have a consultation with an immigration lawyer about that to make sure it will not be a burden or bar in your particular process. So there are speed humps along the way. It is absolutely doable. We are here to help. If you are looking for an experienced, empathetic, thorough, determined, detail-oriented immigration lawyer, we are here to help you through the process. We would love for you to contact us if you are interested, or if you have questions. You can reach us at our website, sumnerimmigration.com. You can call our office, 804-396-3412, or send us an email at info@sumnerimmigration.com, or you can comment, put a question on this video, and we're happy to answer questions to the extent that we can. We can't give legal advice here, but if you have general questions, we're happy to answer. We want to know what you're worried about so that we can help you work through that and come up with a plan. So I hope that you have found this information helpful. If so, I hope that you will share this video with a friend, colleague, or family member, and make sure that you are subscribed to our channel with the alerts on. Otherwise, my name is Emily Sumner with Sumner Immigration Law, serving clients around the United States and around the world with family-based and employment-based immigration matters. Until next time.